I'm having a hard time hearing you, so.
Oh, it might be me. Good morning, Miss Samples.
Good morning, Your Honor.
It does not appear that anything is ready to be called, but since the docket starts at 9, I wanted you to know that I was here and ready. And good morning, Mr. Cox.
Good morning, Your Honor.
Miss Millsma is here if you need to speak with her.
Maybe a few moments would be good. I just want to get an update as to
Okay.
where we stand.
Marianne will get you moved into a breakout room. But Mr. Cox, before you go, someone within the last half an hour dropped off a letter to the court, which is a notarized letter from Jessica Lovetrow, and she puts her address there. Her aunt is Gail Millspa. There was an older man who stopped by every few weeks to see my aunt. She said he was interested in buying her Ford Flex that had broken down and was sitting in the driveway. In July of 2019, I saw him tow the car away. My aunt said she had sold to him for parts. I know the last time we were here, the question was the transfer of ownership date. It just came upstairs within the last 15 minutes. If you would like, we can scan and send a copy, or if Ms. Millspot has a copy, she can read it to you. She also had a statement that says essentially the same thing, that she transferred the car in July of 19. They're notarized letters. I would have sent them to your office earlier, but we just got them this morning.
Yeah, Judge, when we were before you last, I had encouraged Ms. Millspaw to come up with something that I could take to my client that would be a more substantial representation, I think, of what she was saying and give my client a basis to potentially walk away from this. Those might be exactly what we need. So I would very much like to get copies of those to get to my client.
That being the case, Mr. Cox, what's the best email for you?
KCOX at LIW, like Lake and Ingber Winters, firm, FIRM.com. KCox at LIWFIRM.com.
And the court would presume that you would need time to send it to your client to get a response on how to proceed.
Yeah, Judge. So I was hopeful to have those prior to the day's proceedings so we wouldn't have to be here today. I hate to ask for one more adjournment on this, but I think it might serve us all well. If I went into the breakout room with Ms. Millspaw, we'd be talking about the same things Your Honor and I just discussed.
Well, Mr. Cox, let me interrupt you for a second. This is 223024 GC Westland Car Care Towing versus Gail Ann Millspa. Your appearance, please.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Ms. Millspa, your name, please.
Gail Ann Millspa.
Thank you. Mr. Cox and I just started having a conversation about the document that was dropped off to the court this morning. And as expected, his office wants the opportunity to receive it, submit it to the plaintiff for review and response. And based on that, the court would find a good reason to adjourn this hearing. And I hate to do it again to you, but his office needs the opportunity to review the 2 letters that were dropped off this morning and submit them to the client. We can put this over to the next civil date, which is November the 1st, Mr. Cox, if that would give you sufficient time to get it over to your client.
Yeah, I think so. I'm just looking to see whether or not I have an email address for the defendant. Presumably, if my client's on board with what this says and takes it at face value, they would authorize me to dismiss the case, at which time I would need to get a stipulation to dismiss to Ms. Millspaw. Perhaps at the conclusion of the proceedings, I could still go into a breakout room with her and get her email address on our way out. That way we aren't putting it on the court record.
Ms. Millspa, both times that you've appeared, you've been at work, it seems. Is there a better time of the morning for you to be away from your duties?
Nope.
Okay,
I'm the only phys ed teacher here, and quite honestly, at the moment, I apologize for not having responded earlier to Mr. Cox. I literally was very, very ill and literally just remembered that I had to come to court today, like yesterday,
no,
because I've been so ill, and I never get that sick. I apologize, and school has been very, very overwhelming at the moment, losing our superintendent. I have no principal. I'm doing double duty for Jim. And I know that's not your concern, but yeah, that,
Miss Millspa, don't apologize for having life. Things happen, and the letters did come this morning. So what the court will do is put this matter over to November 1st, 2022 at 9 a.m. That's my next civil date. Before you leave this morning, my secretary is going to move you into a breakout room with Mr. Cox so that you can exchange the best contact information. He may submit it to his client, and his client decide to abandon this case, dismiss this case with you. I don't know what they're going to do, but just exchange information with him. I'll see you on November 1st. If something comes up and that's no longer a good day for either you or Mr. Cox, you can reach out to the court and we can get it adjourned again, but maybe you'll resolve it and I won't see you on November 1st, okay?
okay, thank you.
Very good.
Don't
Thank you,
hang
Judge.
up, join the breakout room, okay?
I got it.
Thank
And
you,
then
Your Honor.
you can leave from there.
Thank you, Judge.
Thank you, Mr. Cox. Good to see you.
Yes, good to see you.
See, Marianne, I knew that even if we sent it this morning, he would still need to send it to his client to get a response. And
Yeah,
so
that makes sense.
I'll just wait and it can go on its regular path to get served on him. Good morning, Miss Bailey.
Good morning.
I have not seen Mr. Dunnell this morning. This course policy is 15 minutes after the scheduled start time. So if they're not here, that your defendant's not here by 9:30, I'll get your case called and get you on your way, okay?
Sounds good.
Thank you. Good morning, Mr. Graham Mason.
Good morning, Your Honor. I was over in the other pending courtroom as well. I had to switch over to here. I apologize.
Don't apologize for being busy, Mr. Graham Mason. I understand.
I just don't want to make this court wait either, Your Honor.
Oh, thank you, sir. Are you here for West Village?
Yes, I am. I'm actually here for 2 reopening and entry of judgment cases from bankruptcy. Kind of switching gears here a little bit.
I saw that, and the first one scheduled at 9. We'll see if Ms. Hughley is here in the next couple of minutes. I'll call at 9:15-ish.
And then we have a second for Ms. Cooper, I believe, at 9:30.
Yes, sir. Same rules. We'll see if either one of them appear.
Thank you.
Good morning, Ms. Fulton.
Good morning.
The attorney is here for National Collegiate. Do you need to speak this morning?
Yes, good morning, Your Honor. Yes, I'm here.
Good morning, Ms. Fulton. You'll see an invitation to go into a breakout room with the attorney. Please speak with her, and once you've had the opportunity to talk, come back into this main session. The court will call the case.
They've already spoken, Judge.
Oh, thank you, Mary Ann. This is 150522GC. This is National Collegiate Student Loan versus Trayvon Fulton and Gloria Fulton. May I have your appearances, please?
Yes, thank you, Your Honor. This is Natasha Dixon on behalf of the plaintiff, National Collegiate Student Loan. My P number is 82333.
And Ms. Fulton, state your name for me, please.
Gloria Lynn Fulton.
Thank you. Today is the day and time set for hearing on the plaintiff's objections to the defendant's motion for installment payments. The parties have had an opportunity to speak. Ms. Dixon, how are we proceeding this morning?
Yes, Your Honor, I did speak to Ms. Fulton, and we will agree to the plaintiff will agree to the 35 per month. So she's able to begin those payments, first payment due by November 15th of 2022, and by the 15th of each month until the balance is paid in full. So we'll agree to the 35 per month.
35 per month with the first payment on November 15th. Ms. Fulton, was that your agreement?
Yes, ma'am.
There is not a proposed order in the file. Hold on. I thought I saw one. There is not a proposed order in the file. I'll send the file back downstairs to the Civil Department to prepare an order. Ms. Fulton has indicated in the plaintiff's response, that's an 11-year repayment plan. I understand that things might be financially difficult at this time, but if you're able to pay more each month, this case is already 7 years old. So if you're able to pay more, pay more. Otherwise, the 35 per month will be the order of this court. Anything else on behalf of the plaintiff?
No, Your Honor. So it seems like you said the court will prepare the order. Does the plaintiff need to send anything to the defendant to sign, or?
No, ma'am. The
Okay.
Civil Department will just prepare the order, taking the terms on the record. Ms. Fulton, anything else, ma'am?
No, Your Honor.
Thank you so much. Have a good day, both of you.
All right. Thank you so much. You have a good day also.
Thank you.
Thank you, Your Honor. You too.
This is 221481LT. This is West Village Estates versus Angela Hughley. May I have your appearance, please?
Corey Grand Mason, P 64392, appearing on behalf of West Village.
Mr. Graham Mason, today is the day and time set for hearing on plaintiff's motion to open case after bankruptcy and enter judgment for non-payment of rent. The court did receive the motion notice to appear on August 22nd, 2022. Service has been made upon the defendant. The case was scheduled at 9 o'clock. It's now 9:15 by this court's clock. Defendant having failed to appear. How do you wish to proceed, sir?
Your Honor, we would like to reopen the case from its administrative closing. The bankruptcy is over. The discharge was entered. So at this time, because the lease was reaffirmed, or in this case, continued, we're seeking a judgment to be entered at this point in time for back rent that is owed as well.
And how much is the back due rent, sir?
The back rent at this point, rent to retain possession, is $4,843.76. The cost to file initially was $164.53 for a total of $5,008.29.
Plaintiff's motion to reopen case is granted. Plaintiff's request for entry of default judgment showing rent to retain of $4,843.76, $164.53 in cost for a total judgment of $5,008.29. Mr. Graham Mason, if your office would submit those orders to the Civil Department, they'll send them up for signature. Anything else in this matter?
No, Your Honor.
Thank you, sir. This is 224075GC. This is One Detroit Credit Union versus Stephen Ford. Stephen Ford. This matter was scheduled at 9 a.m. on, excuse me, plaintiff's motion for restraining order, motion for possession pending judgment in this claim of delivery case. Case was scheduled at 9 a.m. It's now 9:17 by this court's clock. Neither party appearing. The motion is dismissed. Good morning, Mr. Goethals. I thought that Mr. Pellegrini was here.
Yeah, he was.
He was. He seems to have disappeared. Mr. Grant, I saw you. I have not seen Mr. Ivanchik this morning. It's still a little early for your case.
I'm fine waiting around for a few minutes, Your Honor.
Oh, he's back. Mr. Goethals, we'll get you matched up with Mr. Pellegrini and into a breakout room if you need to go there.
Thank you, Your Honor.
Mr. Pellegrini? Thank you, Mary Ann. You're just so efficient.
Goes downhill from here.
One of these cases had a consent submitted yesterday, and I think it is. Mary Ann, at the 9/15/222963 portfolio versus Lowe. The case
Yes.
has been the case has been dismissed.
Thank you.
Mr. Graham Mason, do you have somewhere else to be?
No, surprisingly, I don't. I'm just preparing the Hewley documents right now, so I get them over to you as quickly as possible.
Thank you. This is 214149 GC. This is Midland Credit Management versus Danielle Kane. May I have your appearance, please?
Kara Bailey, P73071 on behalf of the plaintiff today.
Thank you. Today is the day and time set for hearing on plaintiff's motion to reinstate dismiss case and enter default judgment. This case was scheduled at 9:15. It is now 9:30 by the court's clock. Defendant has failed to appear. The court has reviewed and the plaintiff's motion and proposed orders attached thereto. Ms. Bailey, is there anything else you want to add?
I believe everything's covered in our motion, Your Honor.
Plaintiff's motion is granted. The dismissal is set aside. Case reinstated. Defendant received notice that today's motion included a prayer for relief that included entry of default judgment. Defendant has not submitted themselves to the court this morning. That default judgment shall enter. Court has signed the order and the default judgment. Anything else, Ms. Bailey?
Nope, thank you, Your Honor.
Have a good day, ma'am.
You too.
Thank you. Are we ready on Crawford and Freeman?
I believe so, Your Honor. My client sent a message saying that they were ready for court, but I don't see them in here quite yet. I don't know if they're in the waiting room.
If you want us to wait for your client, I don't see anyone in our waiting room awaiting entry.
Okay, that's a little interesting.
It's up to you. I mean, we're not in any rush. If you want us to wait, you want to give your client a call, it's fine.
No, I'm okay, Your Honor. I've discussed with Mr. Grand a possible avenue forward on this case, and hopefully just
Okay.
run it by the court and get the court's approval.
This is 222175 GC. This is Crawford Management versus Genevieve Freeman and Manju Freeman. May I have your appearances, please?
Good morning, Your Honor. For the record, Joel Grand, P51261, on behalf of plaintiff Crawford Management Company, Inc.
And John Ivanchik on behalf of Genevieve and Manju Freeman, Your Honor.
Today is the day and time set for the pretrial, and this morning, Mr. Grand, how are we proceeding?
Your Honor, I believe we should set some dates. I know Mr. Ivanchik and I have had some discussions about this matter. However, I think that we should, perhaps we had discussed the possibility of having some sort of facilitation with our clients present. But I think we still should just set dates and get the case scheduled moving forward in case we're not able to get it resolved.
Your Honor, if I may, what I had recommended is using Judge Green as a mediator. Used her before at the court's suggestion, and I found her to be very good at getting cases resolved. But if we want to set dates to kind of keep this on a leash, that's fine.
Thank you, sir. I was going to suggest to Mr. Grand that their Judge Green is in fact an ICL certified mediator for civil matters. And if, Mr. Grand, if you're in agreement, we can send the case to Judge Green to have her schedule mediation.
That would be wonderful. I'm always a big fan of facilitation.
And what I can do for control purposes is put you on my next, well, not next civil docket, because that would be November 1st. I don't know if that would allow you time to do schedule with Judge Green and be seen. I can put you on as an adjourned pretrial for December the 6th at 9 a.m.
I have a conflict that morning, Your Honor.
The 20th of December.
I'm good that day.
I am scheduled to be out of town that week. Why don't we schedule it for the 20th? And if we end up with an issue, I think there's somebody at my office that can handle it.
Okay. We'll put you over to December the 20th, 2022 at 9 a.m. back with me for an adjourned pretrial. In an interim, refer to Judge Green for mediation. Mr. Grant, is there anything else you need this morning?
No, I think that we're fine. I know we've done some informal exchange of documents, and I expect that we'll continue with that. But in the interest of not running up costs, why don't we reserve whether we're going to do any sort of formal discovery until after we've had the opportunity to facilitate.
Thank you. Anything else, Mr. Evancho?
No, Your Honor, we'll reach out to Judge Green's clerk and get on her schedule.
Okay. I'll see you on December 20th. Have a good afternoon.
Thank you.
Thank you. Good morning, Officer Crova. How are you? Thank you for checking on me since my court officer doesn't come up here. Anything could happen to me. I don't mind at all. I just see my next case popping out of the breakout room, just waiting for the other half to appear. Have a good day. I will. Thank you, sir. Yeah, you let Officer Brooks know that Crova checked on me. This is 222832 GC. This is Discover Bank versus Daniel Pellegrini. May I have your appearances, please?
Yes, good morning, Your Honor. Michael Goethals, that's Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
And your name for the record, please, sir?
Daniel Pellegrini, that's Pellegrini.
Thank you. Today is the day and time set for the adjourned pretrial in this matter. When we were here back on September the 6th, this matter was adjourned as Mr. Pellegrini had filed a dispute that was under investigation. Mr. Goethals, how are we proceeding this morning?
Well, Your Honor, I've spoken with Mr. Pellegrini in the breakout room, and we have reached an agreement. The agreement consists, first of all, in entry of a consent judgment, which will be in the complaint amount, $1,726.99, plus $102.88 for our filing and service fees, for a total judgment amount of $1,829.87. We'll mail or email consent judgment to Mr. Pellegrini to sign in return. We'll also send him a letter with the payment agreement that we've reached. And I'd like to put that on the record as well. The payment agreement is that Mr. Pellegrini will make payments on the consent judgment in the amount of $77 per month to our office beginning October 28th, 2022.
Mr. Pellegrini, you were able to hear Mr. Goethals just now,
Yes, I was, Your Honor.
and it's your understanding and agreement that there will be a consent judgment with a total amount of $1,829.87, and that you'll make payments of $77 per month beginning on October 20th, 2022.
Yes, that is, I understand that.
And you've exchanged sufficient information that Mr. Goethals' office may send a consent judgment for you to sign and return.
Yes, we have.
What this court will do, I've noted the terms of the consent judgment in the file. The court will actually adjourn the pretrial over to our November 1st civil date at 9 a.m. If you get the consent judgment signed and returned, the court will remove that hearing date. I just don't want the case to show up on a no progress docket because something hasn't happened and the consent hasn't been executed and filed with the court. So Mr. Pellegrini, if you've received the consent from the office, sign it, send it back to them. Their office will sign it, send it here. The court will sign it, you'll get a copy. You will not need to reappear on that November 1st date.
Okay, I understand, Your Honor.
Anything else on behalf of plaintiff?
No, Your Honor.
Anything else, Mr. Pellegrini?
No, Your Honor.
We're all set. Notation filed that the consent judgment is coming. You both have a wonderful afternoon.
Thank you, Your Honor.
Thank you, Your Honor. You too.
Thank you. Are we ready on Beaumont and Fleeson.
Yes. Sorry, Your Honor. I just got the phone with my client. She's trying to log in. And I see my clients from my other hearing just logged in. So if you wouldn't mind putting me in a breakout room with Mr. and Ms. Friedman, I'll talk to them real quick and then come back, and then hopefully Ms. Fleeson will be here by then.
Thank you. I was just going to tell you that I saw them pop in. Mary Ann will give you an invitation to join the Freemans in a breakout room.
Thank you.
You're welcome. I recognized Mr. Burke, although he was not properly named. Oh, my goodness. Good morning, Mr. Whitty.
Good morning, Judge. How are you?
I am wonderful. How have you been, sir?
Hanging in there.
I have not seen your defendant as of yet. The case is scheduled at 9:45. This court's policy is 15 minutes after the scheduled start time. So if they're not here by that time, I'll get your case called, okay?
Sure. She's
Thank you.
represented, so I think I've talked. She should be here.
I haven't seen anyone from that side. I'll put it that way.
Thank you.
Mr. Burke and Mr. Ivanchek, we were waiting for Ms. Fleeson.
We are, Your Honor, but can you put me and Mr. Burke in a breakout room, and I'll talk to him really quick. I did talk to my client on the phone, so.
Absolutely.
Thank you.
Thank you.
Hold on one second, Miss Bowie. Thank you.
Mr. Graham Mason.
Yes, Your Honor.
This is 220716 LT. This is West Village Estates versus Selena Cooper. Mr. Graham Mason, the court notes your appearance for the record. Today is the day and time set for a hearing on the plaintiff's motion to reopen case after bankruptcy and enter judgment for non-payment of rent. The case was scheduled at 9:30. It's 9:43 by the court's clock, a few minutes short of the 9:45, but close enough for this court's perspective. Notice was sent to the defendant that the motion was scheduled for hearing this morning. Service was made on Ms. Cooper by a plaintiff's office at the same address that appears on the summons and complaint in this matter. The court has reviewed the motion and the attachments. Mr. Graham Mason, is there anything else you'd like to add?
Just, Your Honor, that the West Village went through all of the proper methods to lift the stay in the Chapter 13 after not being paid by either the trustee nor directly. We now come before the court seeking just a default judgment for the possession costs and to reopen the case, obviously, in order to enter such judgment.
Defendant having failed to appear, plaintiff's motion being proper with the necessary attachments, the stay is lifted. The motion again was scheduled at 9 o'clock. It's 9:44 by the court's clock. Defendant having failed to appear. Based on the defendant's failure to appear, default judgment shall enter. The rent to retain possession is
$10,811.72. Costs of $164.53 for a total of $10,976.25.
defendant having failed to appear, plaintiff's motion is granted and default judgment enters with rent to retain of $10,811.72, $164.53 in court costs for a total judgment of $10,976.25. Plaintiff's office to submit that judgment. Anything else this morning, Mr. Graham Mason?
No, Your Honor. Thank you for having me.
Thank you, sir. Have a wonderful day.
Mhm.
Have a good day, ladies.
You too, Ms. Samples.
You too. Judge, can I just interject for 1 second?
No.
No?
Yes, of course, always.
Oh, she got my chat. Forget it. Thank you.
Is it Zagoraris?
Yes.
The attorney is here for Goldman Sachs. If you'd like to go into a breakout room and talk to him regarding this matter.
Well, Your Honor, we've settled it. We just weren't able to
Oh.
get the paperwork in time.
Oh, let me get the case called. Mr. Whitty did not lead with that information. This is 222-833-GC. This is Goldman Sachs versus Lynette Spina. May I have your appearances, please?
Good morning, Your Honor. John Whitty, P66880 for plaintiff.
Good morning, Your Honor. Diana Xagoraris on behalf of the defendant.
Today is the day and time set for the pretrial in this matter. Ms. Zagoraris, how are we proceeding in this matter?
Your Honor, we have an agreement in principle, but I'm waiting for the signed consent judgment still, which I've sent multiple times, but I don't have that back yet. So until I get that, then I don't think you have a.
That's correct. We do have an agreement. I had to get a final okay from my client, which came late yesterday. So I will be forwarding on the paperwork to Mr. Whitty momentarily as soon as I am done with my Zooms, and we can resolve this.
Thank you. Inasmuch as the parties do not yet have a fully executed consent judgment or settlement documents, the court will actually adjourn this matter to November 1st, 2022 at 9 a.m. Of course, if you get the documents executed, submitted to the court before then, I'll sign off on them and get copies mailed. There'll be no need to appear on November 1st. Anything else on behalf of the plaintiff?
No, Your Honor, that sounds good.
Anything else on behalf of the defendant?
Nothing further, Your Honor. Thank you.
Thank you so much. You both have a wonderful day.
Thanks, you too.
You too.
Thank you. Did Ms. Fleeson leave? I saw her a couple of times, I thought.
Your Honor, when I spoke to her earlier, she said she was having phone issues. So
Okay,
yeah, but I'm comfortable moving forward without her at this point, because we're just going to be
this is,
moving
I'm
this
sorry,
out.
give me 1 second. This is
Sure.
220503GC, Beaumont Health versus Tiffany Fleeson. May I have your appearances, please?
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
John Ivanchik on behalf of the defendant, who I believe was here, but is having some connection issues, Your Honor.
Today was the day and time set for the final pretrial in this case. How are we proceeding this morning?
I will let Mr. Ivanchik, how do you say your last name? I know I call you.
Ivanchik, that's fine. It's pronounced like it's spelled, but not what it looks like. So, yeah, if I may, Your Honor, I spoke to, as the court may recall here, last time we were here, my client who works at Beaumont was in the process of trying to get Beaumont to rebill her insurance for a lot of these charges. My understanding is that that occurred, but Mr. Burke has not seen anything on his end to tell him that some of the bills have been paid. Regardless, my client has said that there's going to be roughly $500 left over. So if we could, one more adjournment to hopefully see if something comes out on Mr. Burke's end, or my client gets me the remittances that I can send to Mr. Burke to show that it was paid. And then we can hopefully negotiate a payment plan on the balance for this one, as well as another case that we have.
If that's okay with you, Your Honor, I have absolutely no objection to that.
Will an adjourned final pretrial be sufficient to hold your feet to the fire, or does the court need to set a trial date in this matter?
I think
this
a final
one-
pretrial. Yeah, this is not us being lazy, Your Honor. This is more or less I'm trying to give my
Mr.
client the
Vancheck,
opportunity to pay it.
I
Yeah.
used to represent hospitals. I understand rebilling and getting
Okay.
proof of the payment. It's fine. That's no worries.
Okay.
We'll adjourn this matter over to November 1st, 2022 at 9:30 a.m. back here with me. If we get to be close to that date and you still don't have what you need, reach out to the civil department. We can push it out a little bit more. Or if you resolve it and set a payment plan on whatever the remainder is for Ms. Fleeson, same thing. Just get the settlement documents over. You won't need to reappear on November 1st at 9:30.
Thank you. Your
Thank
Honor.
you.
Anything else, Mr. Burke?
Nothing. Thank you.
Anything else, Mr. Vancheck?
No, Your Honor. Thank you.
Thank you both so very much. Have a wonderful afternoon.
Thanks. You
Have a
too.
great day.
Thank you.
And then there were two.
Now. Here's a good thing, though. I have not seen John Whitty in I don't know how long. I can't even guess. And then we have, let's see, maybe if I typed in the right number. Oh, see, I don't know why keyboards aren't all set up the same way. So you can always type the number without looking. Some are 1, 2, 3, some are reversed. Because Marianne, I have a sinking suspicion. Yes, so top of the page, Brewer versus Spirit. That was adjourned already and that file is not up here.
Oh, yeah, I see it. Okay.
I marked it off and I still was sitting here looking for another 9:30. So we're 9:45. That 10 o'clock case was dismissed, the Rawsonville versus Simpson. So it's Taylor, GI&I, and then Barrington's this afternoon. So when Mr. Morton pops out. So Kropa comes in, checks on me, offers me coffee and water and.
And where is
First-
Ken?
But nowhere to be seen. I tell him all the time, I could have a major paper cut in here and he's not checked. And then the Huron students come today.
What comes today?
The students from Huron High.
Oh, what are they doing?
You know, their class comes, they ask us questions. We ask them questions. Just like an introduction to the court.
Oh, that's
They
cool.
come, I
What,
think, once a semester,
what time are they coming here?
12:45.
Oh, that'll be nice.
They're always fun. And the last time we had students come, one of the young people had just gotten a ticket, not that day, maybe the day or two before. And he's walking around with it. I said, well, you're walking around with it, but what have you done with it? Have you read it that tells you the different ways you can resolve your ticket matter? Is you come early and stop at the traffic counter and speak to somebody? No? Okay.
They're kids. They don't know.
If Ms. Belcher is back, that means that Mr. Morton is not too far behind. Okay. This is 221767 LT. This is GI&I Harbor Club property versus Jessica Belcher, Antoine Lee, and Cortex Williams. May I have your appearance, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Ma'am, state your name for the record.
Jessica Belcher.
Ms. Belcher, today is the day and time set for hearing on your motion to set aside default judgment. You've had the opportunity to speak to Mr. Morton. Mr. Morton, is there any resolution of this matter?
Yes, the parties have spoken. They've agreed to enter into an amended consent judgment with an extended move-out date, Your Honor. The parties have agreed, to a move-out date of October 21st, 2022. I realized that I thought this was a Sarah State first. Since it's a motion, this will be submitted as an amended consent judgment. With the move out date beyond even the statutory time period of 10 days from today's date to the 21st of October. This will be a flat move out, as Ms. Belcher has advised that she does intend to vacate the property. Based off of, and I know she and I spoke about it, based on the Sarah not being approved. And I will add that I advised of her rights under MCR 4.201, specifically the 3-day time period that this judgment would not be final for if she wishes to file a request for a new hearing.
Ms. Belcher, you were able to hear Mr. Morton just now?
Yes, ma'am.
And it's your agreement that you will vacate the property on or before October 21st, 2022?
Yes, ma'am.
And this case had originally been filed as a non-payment of rent case.
I had applied for Sierra.
Correct, Mr. Morton?
Yes, it was originally a non-payment of rent case. Correct, Your Honor.
And you're treating it now like a termination of tenancy?
Yes, now it's just going to be a move out in regards to a termination. And again, yeah, because we discussed and she was provided information that she was not approved for CERA.
And Ms. Belcher, this is what you wish to agree to?
Yes.
And you will be able to move out by October 21st?
Yes.
And because you appear on Zoom, there is not a signed order with the terms the parties just placed on the record. Have you authorized Mr. Morton to sign your name to an amended judgment, or is he sending it to you for signature?
I authorized him to sign.
And Mr. Morton has explained MCR 4.201. The file's been noted. Mr. Morton, if you get that document over, the court will get it signed. Ms. Belcher, once it's signed, a copy will be mailed to you at the address that appears on the file with this court, okay?
Okay, thank you.
Thank you, Your
Anything
Honor.
else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Belcher?
No, no, ma'am.
Thank you, ma'am. Have a good day.
You as well.
Thank you. Mary Ann, our next case is not scheduled until 10:15, so I will step off. If the 10:15 parties appear, we'll get those cases called. Mr. Morton, did you have something else this morning?
I just wanted to make sure, and it sounds like it was, that the Bubar, Simpson, Sierra, Curtis, Rossville matter was removed from the docket.
I signed that order, I think, late last week.
Wonderful. Okay, I just wanted,
Okay.
that's good news.
Thank you, sir.
Thank you.
Mr. Asphalt?
Yes, good morning, Judge.
Good morning, sir. You have yourself labeled as Waterview Farms?
Yeah, that's a mistake. I apologize. I'm here for Taylor Park Apartments.
That's what I thought. Okay. You're a little early. The case was scheduled at 10:15. My policy is usually 15 minutes after the scheduled start time, but based on the nature of the motion, this is 222394 GC. This is Taylor Park Apartments versus Christy Carawan. Today was the day and time set for hearing on the plaintiff's motion to change venue. The court did receive the motion and review it. Was there anything else you wanted to add, sir?
No, Your Honor.
A motion is granted. I've signed the order. It'll be mailed out by the civil department. Anything else this morning?
No, Judge.
Thank you very much. Have a good day, sir.
You too, Your Honor.
Thank you. Marianne, that's it for us until 11:15.
Do you want me to keep us up live or stop and start? Or you don't?
Yeah, we'll come down. There's no point in staying up for 45 minutes to an hour.
Okay,
Thank you.
you're welcome.